been practicing law for, well, since 1998. And I came to law a little different than most of my colleagues. I went to law school and I started law school at age 39. So it's never too late, I always tell people. But before that, I was in the industry. I primarily worked in aerospace, a little company called Northrop on intercontinental ballistic nuclear weapons. Long way from estate planning, but maybe not. What I learned as a program manager was systematic approach to things. This is what program managers do. So if any of you who have known me or ever sat down with me, you'll see that I draw a lot of boxes. And I try to flow chart things and show things how they progress as we go through our life in that. So hopefully today we're going to maybe demystify a little bit of estate and elder law for you, because I think there's a big misunderstanding by many people on the need for estate planning as a fundamental need that we all have. Because as a lawyer, when I see people who don't have proper planning, the outcomes are really horrific sometimes, just depending on what the situation is, whether it's been a car accident, whether it's been Alzheimer's, whether it's been a stroke, whether it's been grandma falling and breaking her hip. You know, things that just happen every day in all of our families, and how it just can completely unravel things if people haven't really thought about the what-ifs. So we'll think about the what-ifs a little bit as we go through the presentation today. Are you ready for retirement? That is the question I want you to ask yourself, and then see where you are an hour from now. So if you kind of keep that in perspective. Just my brag sheet. I think it is important for you, though, as you work with professional advisors, to not just know their name and the company they happen to work for, but who they are, what is their background, what is their education, what is their experience, and why should they be giving you guidance? I think those are all very credible things for you to ask. And the type of work that you're talking about doing, it's pretty important. And you need somebody, I think, with experience that has been challenged with a lot of different opportunities over their career. Also, I belong to several organizations that I think are very fundamental in my practice and how we achieve our goals and objectives as a law firm, and then how you as clients would benefit from that. And first and foremost is Wealth Counsel. It's become the most preeminent estate planning organization in the country over the last 7 to 8 years. I had the great fortune when I first got out of law school. My first legal endeavors was working in a firm that one of the owners of this Wealth Counsel was there. And Wealth Counsel didn't exist. It was a dream. And it turned into quite a reality, and I had the opportunity to write a lot of the legal text and a lot of the training materials that this organization uses, and much of it has survived to this day. So it's really a great organization that provides us teaching, training, and then I'll say the computer tools to fulfill a lot of what we promise you. The National Academy of Elder Law Attorneys and Elder Counsel. Might notice a consistency between Wealth Counsel and Elder Counsel. Elder Counsel is half owned by Wealth Counsel. And that is a group that we focus primarily on elder law issues. And we're going to talk a little bit about in the presentation today, what is the difference between estate planning and elder law? What is the difference? Because I think there's a lot of confusion, there's a lot of marketing hype and things like that you want to put all that stuff aside and not listen to the hype and things like that, because that's never going to serve you very well. Just a little bit about Gregorek and Associates. We're a small law firm in Kirkland, and we provide what I call integrated legal services. And you're going to learn a little bit more about that as we go through today. Why is it important for you to have an integrated plan, and integrated with whom and how? So we'll want to talk about that. We're in Kirkland over at the Yarrow Bay Office Park. Pretty convenient to get to and from. Now, no lawyer would be smart to give a presentation of this type without some sort of disclaimer, part of our asset protection planning. So nothing in this presentation or in answering questions creates an attorney-client relationship, nor does it constitute legal, tax, or other professional advice. Take this as education, but to apply it to your particular situation, we'd certainly, you need to sit down one-on-one with myself or another qualified attorney to do that. So I hear so oftentimes people say, I went to a seminar and I went and did something. That's never a good idea on almost any type of situation like that. So don't act on it. I thought this was kind of a cute little segue into getting started in kind of the wheels of life. Kind of cute. We start off there with our little baby stroller, and kind of looks like we end up in something very similar down at the end there. So hopefully on wherever we are in our stages of life, a lot of what we're talking about in planning has to do with that last row, which I'm interpreting as kind of our retirement years. We're got through the kids and the job's coming to an end, and we're retiring, and off to the motorhome we go, or hope. So there's a fellow named Alan Lankin. Has anybody heard of him? He's an elderly gentleman. I think he's in his mid-80s by now. And he's just been a well-renowned author in that on time management and and planning. And so what is planning? Well, this is his definition. I kind of liked it. Planning is bringing the future into the present so we can do something about it now. And I thought that's well said. And so we'll keep that in mind as we go through today. And during our life, we usually plan for lots of different things. You know, our anniversaries, dinner, vacation, we all plan for things. What other things do we plan for?
Plan for the birth of our children.
Yeah. Well, sometimes that's planned.
Right. Hopefully most of the time.
Well, what about planning for your future care needs? You know, I'm going to show you some statistics in a little while that hopefully make you think real hard about this is real important and very necessary to do. So the question is, what is your aging in place plan? What is your aging in place? That's kind of a term that's used in the community now. Aging in place, we find that most of us, if we do become infirmed as we become elderly, whether it's through Alzheimer's or stroke or whatever that makes us dependent on other help, most of us want to stay in our own home. Is it anybody's goal here to say, you know, my last few years of life, I want to be in a skilled nursing home, acute care center? Is that anybody's plan? Of course not. But I could ask every third one of you to stand up. We went right down here. I'm not going to do that, but 1, 2, 3, 4. 4 in the first row are going to be in a nursing home. I don't know which 4, but it will be 4. And ladies, it's a lot more of you. Okay? You live longer. I don't know if that was smart planning on men's behalf that we die sooner or not, but it is a fact of life. And if you go to any nursing home or thing like that, I think you'll just anecdotally see there are far, far more women than men. So there's the studies. You can read them yourself, and looking at that, 1 in 2 people will need some sort of long-term care. 1 in 2. The type, frequency, and percentage of people who need long-term care increases greatly as we pass age 70. Most people are passing age 70 today. In fact, most people are passing 80 today. Our longevity is really, really stretching out these last several decades. DSHS here says 70% of all people over 65 will need some type of long-term care. Does that bother any of you? You find that a little bit disturbing, perhaps? What I find is most people come into my office and they explain to me why it won't be them. Mm-hmm. That's just the ostrich mentality, right? It won't happen to me. We've got really good genes in my family. Okay. Let me know how that works out, because it really has nothing to do with, a lot there. Alzheimer's disease is just somewhat insidious. I think our medical community is really struggling with understanding it, identifying it, treating it. But meanwhile, we all have to live with it, and people in our families have to live with it. Look at this second bullet. Every 70 seconds, someone in America develops Alzheimer's. By mid-century, someone will develop Alzheimer's every 33 seconds. This is a growing problem. This isn't one of the areas where we see things shrinking or reducing, but this is something that's relatively rapidly growing and really is going to underscore the need for disability planning. So I kind of looked at, over my career and working with thousands of clients and talking with many more thousands, interacting with hundreds and hundreds of attorneys across the country, these seem to be just some common goals that most of us have. You, of course, are going to have many of your own personal goals depending on your own situation. But would these be, fairly reasonable? Aging with dignity, accessing the best care possible, maintaining control over who will manage our finances. That's something I think a lot of folks misunderstand. Doing your planning documents is how you stay in control. Who is going to do what for you if you can't do it yourself? I mean, just think, you leave here today, and tomorrow you're in a car accident, or you're on a car accident on the way home, and you can no longer manage your affairs. You have the proper legal documents in place for either your spouse or your children, a friend, a professional, whomever. Have you chosen who you want to be your, I'll just call them generically, caregivers, paying your bills, making your medical decisions? This is scary stuff, and most of us don't want to talk about it. It's the last thing most of us want to talk about, but if we don't, we're just, again, putting our head in the sand and being that ostrich. So this is something we need to do and be in control, because otherwise it's going to be somebody up there in a black robe. We call them a judge. They're going to have about 5 minutes of information on you, and they're going to make the best decision they think they can make at the time. And very oftentimes, it's not the best decision, and they will admit it. I have one of my clients happens to be a recently retired judge. He sat on the probate court for about 15 or 18 years of his 37-year career on the bench. And I asked him this, I said, do you like appointing guardians? Do you like appointing administrators? He says, oh God, no, I hate it. He says, I never have enough information. I don't know enough. And part of that's because of our rules of evidence and who can talk in court and how you can talk and all those kind of things, and the cost of court. So we really want to make sure that we're taking control of our own situation by saying who's going to do that. I mentioned that we believe in integrated planning. Well, for people in general, this is kind of the way things are happening. If you have legal documents, they're off one place, you saw your attorney 15, 20 years ago, you probably don't remember his name, and if you think hard, maybe you'll remember where the documents are. We've come across that quite a bit. Your CPA, maybe you take your shoebox of receipts in once a year and your CPA does your taxes for you, but is your CPA actually helping you manage your taxes? That's the thing we'd like to see. Your financial planning, insurance planning, are you meeting regularly with your financial advisors? Do they have a plan? Are they sitting down and help guide you? Or are they just order taking? If you're financial advisors, your CPAs, other people, just take orders. That's not really helping you. What we should be looking for is guidance from them. And I will give a plug for Tom and Don, especially here in the local area. Working with Tom and that. Anybody here working with them right now with Vestry, besides me? Oh, okay. So a few of you are. Great, honest guys. They're going to make you feel good, and they're going to put you into appropriate investing strategies. So do check them out if you haven't. And then we have our health and housing issues. But right now we just got these bubbles all floating around in space, not integrated. Okay? It's just all it's not there. And therefore, nothing's going to line up right. Remember I said I'm a planner. I like all the boxes to hook up, and I like connectivity. So we're going to talk about that. As we go through life, we look at a lot of the risk that we face. These are, again, generic risks, but it's something that's common to all of us. If we're looking at, goodness, is the economy pretty crazy? Up, down, stock market's nearing all-time highs again. Is that good or bad? I don't know. We'll have to wait till Monday and find out. We'll have to see. Our market changes. The real estate market, it's up, it's down, it's all over. Taxes, my goodness, taxes have been crazy the last 5 or 6 years. Which way are taxes going? Okay. More money out of our pockets. Our health obviously changes over time. Creditors, predators. I've added the do-it-yourself planning only because one of the more profitable areas of our firm, in fact probably the most profitable area, is when we do contested matters. We call that litigation. Mr. Ralston's our Director of Litigation Services for the firm, and he can tell you with some degree of specificity that all of the lawsuits that seem to arise in the estate planning arena, either pre or post-death, almost always have a foundation in a lack of a plan, a bad plan, wrong plan, self-help. These are not areas that are very easy to deal with. And that's just the way it is. You pay now or you pay later, so to speak, as far as your planning goes. Well-meaning friends and family. Well, what we did for Grandma, but how is Grandma similar to you? Grandma was Grandma, and you're you. And what did Grandma have, or what didn't Grandma have? And just because grandma did it this way and nobody said anything doesn't mean it was done properly. You know, if we're driving home today and there's not much traffic on the freeway and you go 75 miles an hour, you go home and you tell your buddy next door, hey, I drove 75 miles an hour on the way home from the freeway. That doesn't make it right, it doesn't make it legal, and it doesn't mean that the next time you get on the freeway at 75, you're not going to see the little lights behind you and go, oops, I'm going too fast. Wrong advisors, wrong planners. But the number one reason, you know, that we face a lot of risk is our own procrastination. You know, we're kicking the can down the road, sweeping it under the rug. I always love that one. What do we get when we sweep all our problems under the rug? We get a lump in the rug, but we haven't solved any of our problems or that. Competing priorities. This is another excuse. Got all these different things. You know, reducing taxes, you know, children, grandchildren issues, long-term care, inflation, retirement, spousal security, sale of my business if I'm a business owner, my health, my charity, and then add in all kinds of other things. I mean, and there's 1,000 reasons that I can procrastinate. What we like to assist you with is a list of items here where we can really identify your issues, your concerns, because it's all about you and your family, and put those into perspective. We've got to get a reality check. This is a reality check. Ascertain resources, that's part of our reality. And I think they said in the other one, you know, it's sure nice to have money. Money does help. You know, money may be the root of all evil as well, but we all know that if we go into retirement and we're not pulling in our earnings anymore, we're not working, if we don't have a financial engine properly working for us, we're going to have a little bit of trouble, because living merely on Social Security is going to be a meager existence at best. So we need to really look at that. Your goals, your objectives. Moral, ethical viewpoints as far as estate planning goes. There are a number of these that for some people are very, very important, not for others. It's just something, this is why it's so personal. Depending on your situation, your finances or lack thereof, we want to look at government programs, Social Security, Medicaid, VA. Are these going to be part of your future? If so, we should plan accordingly so you don't make mistakes to be disqualified from those programs. I had a couple come in just yesterday, and they had been dealing with an aging parent, mom, and doing all kinds of things that seemed right. Unfortunately, everything they did was wrong, and ended up disqualifying them not only for their VA benefits, but for Medicaid. They're going to have to, in order to correct all the wrongs that they've done, they're going to have to self-fund mom now for several more years in a nursing home, and mom has no money. So the family's all trying desperately to pitch in and figure out where is the $8,000 a month going to come from. Kind of messy. Individual needs, issues, your options including intestacy, guardianship. Intestacy is when you die without a will. You die intestate. You don't want to do that. That's the king's plan. You know, our wills came about under King Henry VIII. So is that, you know, and they haven't changed much. So does that sound like the plan that you might want to have, the state's plan? Probably not when we get into it. Guardianship is during your lifetime if you're incapacitated and you don't have a caregiver identified in your estate plan, a trustee of a trust, an agent under power of attorney, something along those lines. If you don't have that, you become incapacitated, aren't going to be able to care for yourself. A judge is going to decide who provides your care and under what terms and conditions. I would suggest that you will do a much better job of coming up with the terms and conditions and the choice of who you want to be your caregiver than a judge will. We've already talked about that. Then review your update, revise, create your estate plan. You know, you've got to do it all. Planning, I want you to remember, is a process, not an event. We plan, and then we adapt that plan for reality as it constantly comes in and changes. I think Jim Zorn's talk today about, you know, all the work that goes in behind the scenes of calling one play. You know? And they spend millions of dollars in planning this stuff. I mean, you know, the NFL really go out there, and I know it's kind of, you know, not necessarily the most politically correct thing to use sports metaphors and things like that, but there's a lot we can learn from that in the planning. And then, okay, well, I've got my plan, I'm looking this way, but life threw me this little curveball over here, so now my plan's going to have to be modified, adapted to figure out what we're going to do. So creating a maintenance program to help keep your plan up to date is really, really important. So when we look at integrated planning, we're going to bring all these areas together. And working with your financial advisor, with your CPA, if there are health and housing issues, working with your professional people, maybe that's one of the geriatric nurses over at Andalcare. If all of your professional advisors actually talk together, with your permission, of course, you have to provide that permission, but I can tell you from my experience that when you have an integrated plan and when your advisors are all on the same page, working on the same set of goals and objectives, you win. You win. You're going to do a much better job of your planning when all of your professionals are issue spotting for you and saying, hey, Bob, you know, such and such, you need to go make sure you see Rick. Or I might say, well, you know, I really want you to make sure you go see your CPA on this one because there's going to be an unusual tax situation or something. So it really, really helps. And in establishing your plan, input from other areas outside of just the lawyer really makes your plan, I'll just say, superior to just kind of trying to do it yourself. Everybody likes lists, so David Letterman came up with 10, so I have 12. No plan, wrong plan, outdated plan. I want to go through these fairly quickly in just the interest of time, but I think you'll get the flavor as we go through the thing. The disturbing thing here is only 10% of people have proper and current plans. That's not my statistic. That was from the American Bar Association. That's on a nationwide basis. We in Washington are no different. I actually went to a very large estate planning conference a number of years ago, and by a show of hands, they asked how many attorneys in the plant actually had their estate planning done. About 20%. Goodness sakes, you know, so you can lead a horse to water, but making him drink sometimes is very difficult. So, you know, you want to do that. Loss of control. No incapacity planning. I cannot underscore how important it is to have developed, you know, planning in place that what if I can't make my own decisions tomorrow? What if? That's really what we're asking. Your privacy is at risk. You know, if you have to go into a guardianship, everything about you is public information now. And best of all, it's on the internet. So I don't know about you, but I'd like to keep myself off the internet as much as possible about my private affairs. Hopefully I'm out there lots for my business so you can find me. But personal stuff, boy, very scary place, okay? No backup planning. I see this happening so frequently. People go in and they say, oh, I've got my wills done. And I read the wills and it says, you know, the husband's will says, you know, when I die, I appoint my wife as my executor, which we now call personal representative. That's it, no backup plan. Oh my goodness. Well, that's not really good. It doesn't even sound right. Everything we do in estate planning, we want to have a backup plan. And if not A, then B. Well, if not B, then C. Stay in control. Chart your course for success in your endeavors, okay? Does your plan allow for modification if there happen to be disputes or ambiguities? How are those handled in your documents? Are you going to want your caregivers and the people involved to automatically have only one choice, that being court? Or do you want to have some other alternative methods for settling disputes within your estate plan? And there are several really good plans, and we come up with new ones all the time. What if there's a change in the law and you are incapacitated or following your death? Can your plan be modified to take advantage of those things? The answer is going to be perhaps, depends on which laws and which things, but many, many things can be reformed during your incapacity or following your death if you've pre-authorized it. So you have to take the first step to say, well, if things change, I want to be able to handle those changes in this way. And then we put those types of features into your documents. No maintenance plan. It's the same as buying a car and never changing the oil. Probably not going to run a long time. Okay? So, and it's not going to serve you well. It's not going to be reliable. Maintenance makes things more reliable, right? So it's a lifelong process. A lot of people ask me when they come in is, when's the best time to estate plan? And when should I do my estate planning? Anybody have the answer there? Well, yesterday's a good 18. Because what happens when we turn 18?
Legal adult.
We're a legal adult. How many people have children or grandchildren and they're about 18, 19 years old? You know, are they really adults? Are they really ready for the world? Well, same thing for us. They're legal adults. I really wish in our high schools and colleges there'd be more training about this so people would have more understanding, but tough one to fit into the curriculum. But it's a lifelong process. If you haven't done your estate plan, then the obvious time is now. Waiting doesn't help things. Procrastination is the worst thing you can possibly do in your estate plan. So it needs to be monitored, reviewed, updated. How often should one review their estate plan? Guesses?
Changes.
This guy right in the front row, annually, absolutely. Now, does that mean you have to spend a ton of money and come see the lawyer and spend $1,000 to review your plan every year? That's not what I'm telling you. I teach all of our clients how to do self-annual reviews. Come in and see me if you've had changes in health or changes in wealth or changes in circumstances. You've changed your mind. Maybe one of the people you've named in your plan as an agent, see, they were in a car wreck and they're incapacitated. Well, they're not going to be your agent anymore. So maybe you need to come in and update the people in your plan. No inheritance protection. This is becoming more and more and more important. And it was kind of interesting. When I first started practicing law back in 1998, there was a lot going on. The dot-coms and everything was just flying high and lots of shake and bake instant millionaires. And our firm was actually contacted by the Wall Street Journal, one of their reporters. And they wanted to know about all this new wealth and how people are planning. And it was kind of interesting to me to find out a lot of things we were doing in my firm, and I just started practicing. I'd been practicing less than a year. And yet we were doing very advanced planning at the time and very state-of-the-art planning, what turned out to be probably 10 years ahead of the market. And they ended up doing a rather cool article. In fact, it was for those familiar with the front page, they have a column down the right side on the front page, and that was called Trust Me, Baby, trust in quotes. And then if you opened up, I forget which section it was now, and there was what they call both pages, full pages. It was one of our clients, and clients, of course, had given their permission to do all that. So it was a young couple, about $9 million estate, under 30 years old, very successful. What company did they work for?
Microsoft.
Microsoft at the day. And all the planning they did. Now, they were chosen, A, because they met all the financial profiles we were looking for, the age, the new millionaires, the nouveau riche, but they also had a lot of good photo ops because they had triplets. So it was kind of fun. But it was talking about asset protection. How do we protect our assets? Now, so there's asset protection for ourselves, but then what we're talking about here is when you pass along to your spouse, to your children, your grandchildren, how do you do that in maybe a safer environment than just giving it to them outright? When I own that asset outright, I inherit something outright, that money's at risk. Failed marriage, lawsuits, creditors, predators, all kinds of stuff, right? Well, what if we put it in a trust? A protective trust that's immune, that in a failed marriage, it's not a community asset. What about bankruptcy? Something happens, people go bankrupt. Good people go bankrupt. That's just the reality of life. But if you have your money inheritance in one of the, in an asset protected trust, that money's not available. That's pretty powerful stuff to start thinking about it. And then maybe your grandchild is inheriting that. Well, what's the divorce rate? Well, it's 50% plus at least. I think I gave a statistic on my radio program a few weeks ago that 95 million Americans are in step relationships. Multiple families. We call them the blended families. This is huge. And it requires extra care and planning. Just as a sidebar, those who are in subsequent marriage and have families, multiple families, if you will, and maybe have kids from the first marriage and the third marriage, and your spouse has kids from their second marriage, this is really tough. And just getting that all planned out and how is that all going to work is quite a challenge sometimes. No nursing home planning. The number one threat that all of us have in this room against our estate against our finances. Our number one threat is our own health. Okay? I think Marla was giving some rather scary statistics on the cost of care. It's not going down, folks. It's tripling, at least tripling the rate of inflation. So we're talking around 9.5%, 10% annual rate of increase in the cost of care for senior care. It's just getting very, very expensive. I've had clients spend $35,000 to $40,000 a month to keep a loved one at home. Not many of us have that kind of resources to do that. Maybe for a month, but try that for a couple of years. Pretty daunting, so we have to be really careful. Again, we're seeing the statistics. 65% of nursing home residents spend their entire life savings within the first year. Doesn't mean much for the spouse that's left behind. No estate planning for life insurance. One of the mistakes I see a lot of people have is they might have $1 million insurance policy. And that insurance policy is a taxable item for estate taxes. Okay. Everybody aware that Washington has an estate tax separate and distinct from the federal government? Is there anyone not aware of that? The federal government, it's $5,430,000 this year. Each one of you, the first $5,340,000 is exempt from your estate taxes. But in Washington, only $2 million. So I want to caution people, if you're reading in a newspaper or you're hearing on TV about estate planning and things like that, invariably you're going to hear statistics about the federal estate tax. And they're going to tell people about portability and about a whole bunch of things that says, well, you don't need to do certain types of estate planning that you used to have to do 10 years ago. Well, they should say, except in Washington. Comma, except in Washington. Now, we're not the only state that has a standalone. About 20 states now, 19 or 20 states have their own standalone inheritance taxes. So we have to give some very special planning for Washingtonians such that we don't end up paying an unnecessary estate tax to the state of Washington, okay? And also just remember that life insurance is taxable, okay? It is taxable in your estate. So we want to pull that life insurance out of your estate if it would make you taxable. And we do that through trust. The answer to many of our solutions is going to be a trust. And then it's going to come back to what type of trust? What are the terms, conditions, provisions? What are the things I like about the trust? What are the things I don't like about the trust? So we want to take care of all those types of situations. For people who own real estate, real property in multiple states, most people would, if asked, would say, well, I'd like to, avoid probate. It's a good thing. We would all like to avoid that if we could. It's a governmental process, and we can avoid it, but we need to plan. But if we don't want to do one probate, we certainly don't want to do two or more. So when you own property in any state, that's going to trigger a probate in that state. So if you're a Washingtonian, but you own property down in Arizona, and you die, and you haven't properly planned for that, you will open up a probate here in Washington, and then you'll get the court here in Washington to do some fancy documents for you to send down to the court in Arizona, where you will open up an ancillary probate. Cost, time, money. So we want to avoid those types of things. And I've already talked about, the guardianship process. The probate process itself is public as well. About 7, 8 years ago, we went on the internet. At first, when the court put them on the internet, they forgot to take your account numbers off and your social security number. And there they were on the internet. Well, thank you, government. Very, very shrewd of you. They do redact that information now, and they catch most of it. But there's always some inadvertent potential harm there. So we really want to be careful on what we get into public. No income or estate planning for retirement plans. This is really becoming a much bigger topic today as a result of a U.S. Supreme Court case, which I'll talk about at the end of the presentation a little bit, called Clark v. Ramaker, and on the ramifications of asset protection vis-a-vis inherited IRAs. We have a whole new set of laws, new game since June 12th of this year in that. So we want to really take care of these really important assets. For those who are maybe a little better off or have a desire for charitable planning, let's have a savvy gifting program. on how are you going to do your charitable program. Okay? For business owners, a business legacy. One of the things I learned very early on when I started practicing was that, you know, people that own their own business, well, maybe they had a business lawyer over here and he's doing this thing, and maybe they had an estate planner, remember the integrated thing? And those things weren't connected. And yet, when people come into me as the estate planner, their business is a large part of their estate, if not the bulk of it. If nothing else, it's the creator of their estate. We really need to align business, this is for those of you who are business owners, in that and how those things are taken care of. I think I said this quote a little earlier in the morning thing, but it's just a definition that was developed about 20 years ago, and I kind of like it. It kind of says it all. It has a little element of, in estate planning, oftentimes I tell people you got to be kind of a little bit selfish because you got to take care of yourself. You all flown on airplanes, right? And you know, you get the flight attendant, they come up every time and they tell us how to buckle our seatbelt, and they tell us that the oxygen mask is going to come down, it's not going to inflate, but they always tell us put our own mask on first and then help children or the elderly or someone else. And they do that because we only have about 15, 20, 30 seconds before that cabin depressurization is going to make us go to sleep. So we don't have a lot of time typically to act, so get our own on, and then we can help each other. So that's, when I talk about, maybe that's selfish. Oh, gee, look at, they're putting their own mask on first. But if they don't put their own mask on, they're not going to be able to help the others. And then I'll have 3 casualties maybe instead of 1 or 2. So anyhow, just think about that a little bit. When I first started practicing, a lot of the idea was, how do I, as a new lawyer, know that I am working with my clients, I'm covering all the bases? What are all the options that might be available? So myself and several other attorneys, we sat down for a number of years and we created what we call our wealth plan system. And it has 4, since I'm a guy, toolboxes. Okay, so we have 4 toolboxes. We're just talking a little bit today about primary tools. Primary tools are things that all of us need to have in some form or fashion in our estate, whether we're Bill Gates rich or not. Okay? Primary, wills, trusts, powers of attorney, core savings, core insurance, everything that we basically need to have. And then our other interrelated planning opportunities for charitable planning, anything we can do during our lifetime or after our death is going to be covered under the philanthropic tools. Wealth transfer tools are primarily a set of mostly irrevocable types of trust where we're transferring wealth from one generation to the other generation in a tax-savvy, asset-protected manner. Okay? Simple to complex. You know, when you set up a 529 college plan for your kids, you know, that's a mutual fund, number 1. It's actually a trust, number 2. And it's an easy one to set up. Now, is that the best retirement plan? Well, we should discuss, well, what other options do we have? Up to and including your own. You can create your own educational plan for your children or grandchildren through creating your own trust. And what are the rules? More flexibility, perhaps, than what the government might allow you. So pros and cons on everything. I said I'd mention a little bit about what is the difference between traditional estate planning and elder law. So going back to our planning models, but traditional planning anticipates future events. We anticipate, what if? What if I become disabled? What happens upon my death? So we're considering those things. To me, elder law and special needs planning to some degree generally involve a current situation involving a new or escalating medical condition. I have clients that are 85, 90 years old. I don't consider them elder law clients. Some of them get up every morning and go to work in their 90s. Awesome, unbelievable. It's a case-by-case basis. There's frailty, there's diminished cognitive abilities. Those are the things that shift us over. And then lack of resources. Most people who go into the elder law planning arena really are looking towards governmental assistance at some level to help them possibly get through the rest of their life. 2 types of planning, and I'm running a little behind, so I'm going to kind of pick up the pace here a little bit. So will-based planning, trust-based planning. Neither one is a document all by themselves. We're going to have powers of attorney, medical directives, living wills. You know, that's the, everyone calls that the pull the plug document, what happens at your end of life, healthcare directives, property agreements for married folks and non-married folks. Does Washington have common law marriage?
Yes.
The answer is no. We do not have a statutory common law marriage. We have something far worse, far more sinister. We have judge-made marriage. They call it a meretricious relationship. They even made up a word for it. Two people living together in something more than a mere roommate relationship. I'll let you think about that. It's pretty scary. Now remember, on our integrated planning, we want to sit there and we bring in our other folks, your financial folks, assessing your reviews, your investment plan reviews, your financial plan reviews. Do you have the resources? That's very integral to me as your estate planner, is how are your financial resources? Are they going to be there for you when you need them? Insurance, do you have the right type of insurance? I tell more people to get rid of life insurance than I tell to buy life insurance. Many of us, the need has passed. Maybe we need long-term care instead. Okay? Tax and compliance. Nothing worse in the world than getting in trouble with the IRS, so we want to try to keep all that stuff done. Will-based planning, people are somewhat familiar with that, although still somewhat confused. A will goes to probate just like no will goes to probate. The personal representative is what we used to refer to as the executor. They handle your affairs through the court after the court appoints them. You ask the court to appoint someone. They have to approve that. Okay? So there's no incapacity planning when you do a will. I have lots of people, they say, oh, I've done my estate plan. I said, what do you have? He says, I have a will. Well, will only acts when you die. The will never, ever speaks for you during your lifetime. It's after death is when it speaks. It has no bearing on anything until then. Okay? Trust-based planning, the revocable living trust, I like to simplify it, because we start talking about trust, I think a lot of people start, oh boy, that's getting technical and scary and all that kind of stuff. What is it? Folks, it's a long letter of instruction. Okay? It's a letter of instruction. And I like to break it down into, well, while you're alive, well and okay, if you're using the revocable living trust, you're in charge of your stuff and you can do with it as you please. It's yours. It doesn't change. It's still your stuff. You can do with it. You're alive, but you're unable to manage your affairs. This is probably the single best reason to do a revocable living trust. Now, most of my colleagues will tell you the reason to do a trust is to avoid probate. To me, that's the icing on the cake. The cake, the biggest benefit of a living trust is going to be protection of your assets and management of your assets during any disability. So who are the parties to a trust? Trusts are an interesting legal document. They're a three-party document. Most contracts are what we call bilateral, two people. This one has three. You've all had trust. You just took a mortgage out on your house. Technically, we don't have mortgages. We have deeds of trust, right? Everybody signed a deed of trust? That's a living trust. You were the grantor, which I call the trust maker. That's the one who makes the trust. The trustee is the manager. They carry out the instructions of the trust maker. And then the beneficiary. Well, in your own revocable living trust, you're the beneficiary. When you die, there will be death beneficiaries, but during your lifetime, you're the only beneficiary, okay, you and or your spouse, okay? So those three parties, and in a revocable living trust, you start off as all three parties, if you want to. I've never yet had a client that didn't want to, that was able, but that's the way it is. So for estate planning, the individual, married couple, whatever, registered domestic partners, everybody can be all three parties simultaneously. And that's a little unique in trust world. Many times if you create certain types of trust, others would be the beneficiaries and someone else beside you would have to be the trustee. So again, different types of trust. So for the estate planning trust, you're in charge completely. It prevents court control of assets at disability. It avoids probate at death. It provides a maximum privacy. It prevents unintentional disinheriting, and it can either reduce or eliminate estate taxes. Now, I got to be honest with you, whatever tax planning I can do for you in a trust, I can do exactly the same trust planning in a will. Okay, so they're tax neutral. So that's not a differentiator. Durable powers of attorney, one of the most widely misunderstood documents. And Scott, would you agree it might be one of the most abused documents out there?
Yes, it is.
Yeah, boy, oh boy, you got to be really careful. What powers are you bestowing upon a person? When are you bestowing them? And what checks and balances have you put in there? Okay? If you don't do those things, boy, it's scarier than a blank check floating around out there. Okay? Now, remember, a power of attorney that's used for estate planning, it terminates when you die. It does not survive your death. It'll survive your disability if it's a durable power, but it does not survive your death. Your will or your revocable living trust death provisions will take over at that time. Okay? When we talk about durable powers of attorney, what things are we talking about people managing for you? Well, you can read the list up there, pretty much everything you own. But you want to say, you know, how far can they go on each one of these things? You know, it's very important that you have a thought process going into how do you want to establish the various powers that you're going to grant to someone else, whether it be your child, a friend, a relative, whomever you're going to do that to. Little checklist I put in there for you about does your power of attorney pass the test? I'll let you, for those of you who have them, go home and look at those. We want to just make sure that we're covering all the important aspects that we really need to cover. HIPAA. Anybody heard of HIPAA? That's a fun one. You know, it's the federal government, God bless them, they try hard, but boy, they seem to just screw everything up that they do. Here was a good idea, protecting our private health care information from those that don't need it, like perhaps a potential employer. You know, can you imagine having to go through the employment process and they'll say, well, we'll have to see if you're genetically fit for this job. Kind of scary. Kind of like standing in your underwear letting the manager check you out. How many have had a job interview like that? I did. I never played professional football, but I was in the military. I walked through a line of about 1,000 guys getting shots on both sides in my skivvies. A little humbling, huh? A little humbling. We need to address HIPAA for each and every one of you so that you make sure you have the proper people with proper access to your medical information to help facilitate your care, and not under the standard the federal government has provided, because it's an unattainable standard. They say you have to be found to be incompetent in writing by a physician. You're not going to find too many physicians to do that, because I'm going to tell you a little secret. The determination of incapacity is a legal matter, not a medical matter. Medical doctors simply write opinions. The court will decide if you have or do not have legal capacity. So a doctor cannot write that letter in Washington. I don't think he can write it in any of the other 50 states, but that's the federal law. You know, federal law tells the states what to do when sometimes they don't really have the right to do that according to our Constitution. But, you know, I tell you, as little people, we have to deal with that through our voting. But in the meantime, what we have to do is protect ourselves, do what's right for us. And so through proper HIPAA waivers and things of that nature, these are an integral part of your estate plan. Medical durable powers of attorney. I separate medical powers of attorney from financial powers of attorney for some very good reasons in my mind. One is they turn on differently. Before I want someone to be able to take over my finances, I want some type of determination of my capacity, whether it's from my family doctor, whether it's from my spouse and my doctor, or my kids and the doctor, or it's two doctors or whatever. I want something that says, you know, maybe I'm not right, and I need to, you know, give up the reins. But I want some checks. Now, in medical, it's 2 a.m. in the morning, you're in a car wreck, you're conked on the head, and you're unconscious, and you're in the hospital. Do I want that power of attorney to require a writing by a doctor to turn it on? Well, of course not. I want it to be a light switch, ideally. If I can't give medical direction myself because I'm unconscious or whatever it is, I want my medical power of attorney to turn on just like that, automatically. If I wake up from that car wreck, you know, 3 days later, I got a headache, and I'm okay, I want it just to go off. I don't want to do a bunch of writings and things like that. So I think a properly drafted medical durable power of attorney will, in fact, do that for you. Do not think of that as a living will. Living will is a separate document. That's the one that says if my death is imminent, with or without the application of life support, please allow me to die naturally. If I've been put on life support and it's only artificially prolonging the process of my dying, please remove me. That's the pull the plug document. Folks, every one of you need a customized living will. Statistics are about 60+% of all living wills in the state of Washington are declined by the medical provider, the hospitals and doctors. Why? Because people generally use the state form, somebody printed it off the internet, and they say, you know what, we're not sure this person really had informed consent. And so, you know, we're the hospital, we're going to let a judge make that decision, and then you have kind of a Terry Schiavo situation. We don't want to do that. We want to demonstrate in your document that you understand it, and by your own hand, that'll show. So we'll do that. So we'll make sure that those things work. So your healthcare durable power of attorney, maintain autonomy, privacy, voids guardianships in many situations. Just real important. Many people have older powers of attorney that are not HIPAA compliant. I've seen people's powers of attorney turned down because they didn't mention HIPAA, when HIPAA wasn't even a law when that power of attorney was drafted. I think that's a wrong decision on that party, but it's reality, and it happens more than think. Hence, again, keeping things up to date and keeping them current. Wanted to talk about Clark v. Ramaker just a little bit because I think this is going to impact a lot of people, and you're going to hear a lot of different information on it. But June 12th, 2014, U.S. Supreme Court unanimously held inherited IRAs are not retirement funds. When we say the court held, that means that they decided. Now this was a big one. We had certain Federal District Court saying they were asset protected and retirement funds, others saying not. Went up to the Supreme Court. How many times have you heard in the news recently where all 9 justices of the Supreme Court agreed on anything? So when all 9 of them agree on something, it's pretty solid. So they came down very conclusively that inherited IRAs, that's going to someone other than your spouse. If your IRA beneficiary is anyone other than your spouse, that's called an inherited IRA. And since it's not a retirement fund, it will no longer be protected, whether it's in bankruptcy or through general creditors. So it is an available resource to your judgment creditors. And the court distinguished this for 3 reasons on why is an inherited IRA different than your contributory IRA or the rollover from your 401k into your IRA or a spousal rollover, all kinds of different IRAs. And here's the 3 reasons. It says the holder cannot invest additional money, okay? The holder is required to withdraw from the accounts no matter what their age. So if a 5-year-old inherits your IRA, they will start taking out required minimum distributions at age 5. Okay, that's quite unique. And whoever inherits that IRA may withdraw the entire balance anytime prior to age 59.5 with no penalty. Okay, so we're all familiar with the IRAs. If you pull money out prior to age 59.5, there's a 10% penalty, so that's done. Bottom line is that inherited IRAs are no longer safe from a creditor's reach. Okay, so planning opportunity, right? By show of hands, if I was to say what type of legal document might we use to asset protect our inherited IRAs? Anybody have a guess? Trust. Excellent. See, trusts are wonderful things. I just love these things, right? Because it's what do they do? So you create what I call a retirement trust, IRA trust. The name doesn't matter. It's a trust. And you name that trust the beneficiary of your IRA. Now, I'm simplifying it greatly. This is a complex trust. It is not what we consider a simple trust. It is definitely complex, and it is definitely a trust that is created to satisfy the Internal Revenue Service. Okay? But in the end, it will asset protect your inherited IRA for the person inheriting it from failed marriages, bankruptcies, other creditors and predators in all 50 states. So it's a pretty powerful tool. So I just wanted to make sure, since that's brand new law, that we talked about that just a sec. Oh, there's my solution. I prompted you, so we've got that. The Irrevocable Inheritance Trust. Okay? Please do not make your revocable living trust the beneficiary of your plan unless your revocable living trust has very, very specific provisions in it. Most revocable living trusts that we write as lawyers will violate certain rules the IRS has on if a trust can be a qualified beneficiary for a retirement plan. So we have to be very careful. Okay? First steps, where do we go from here? For those of you who would like to have a consultation with us, we would love to see you, of course. It's absolutely free. You've got some incentives to come see us there. What I would ask you to do is when you schedule your appointment with us, we need to know if you're single or married or involved in registered domestic partnership, and we will send to you snail mail or email what we call our life plan organizer that's going to help you identify your family information, your assets, your liabilities, your goals, risks, and concerns, all in one little place. Gives us a good foundation to start a discussion about your estate plan on.